Hi everyone, my name is Kang. I'm teaching at Peking University School of Transnational Law, and also I'm a member of ECGI. It is my the great honor and pleasure to be the first session of the first Asian Corporate Law Forum. So today, the first session is beginning with the Professor Chun's article. So let me.
Start there? Or?
You can go ahead.
I should say the camera, I should have said, this is being filmed, so please speak into the mic, but you can walk anywhere because they'll capture you, or you can speak to the phone.
Okay, thank you. Good morning, everyone. I'm very happy and a bit nervous to be the first presenter of this very meaningful conference. My topic is about business judgment rule. More specifically, comparison of business judgment rule on the U.S. law and Korean law. It's not a fancy and cutting-edge topic. It's rather a traditional or classic topic, the business judgment rule from the perspective of a comparative study. So here are the research questions that I want to address in this presentation. I mean, the business judgment rule is often regarded as a hallmark of U.S. corporate law, and the Korean Supreme Court openly adopted that rule. I mean, using very similar wording. So it may be said that it is one example of the so-called convergence of corporate law under strong influence of U.S. law. But if we look in more detail, the situation is more complicated. They apparently look similar, the wordings are quite similar, but are they really similar in substance in terms of the element and the effect of the doctrine or the scope of application? Is it really similar? If the elements or scope are different, then are the actual outcome really different? So if we look into the kind of look in more detail, the apparently similar doctrines may reveal more intricate differences. That's the point of my presentation, and that's the short answer is already appear in my topic, the title, the similar rhetoric, different elements, but converging outcomes. So I will go in more detail. So I will firstly briefly mention the background of the discussion, and I will explain or summarize the business judgment rule on the US law and Korean law. Then I will compare these two, and I will look into overall outcomes that we can witness in Korean court precedents, and then I will conclude. As everybody here knows, the convergence of corporate law and corporate governance was a hot topic. So despite the persistence in each countries, at least we cannot deny that there's at least a partial convergence among the corporate law and corporate governance globally. And that happens through various mechanisms like the harmonizing national law, or dual listing, or international soft law, or the so-called transplant or reception of foreign law. Comparatively, say the Korean corporate law, I mean, Korea itself is generally regarded as a civil law jurisdiction, and it is under the strong influence of German law. But the Korean corporate law has also this notable influence from US law. And the business judgment rule may be one of the notable examples. We talk about legal transplant or reception, and there is a controversy about the terminology in the field of comparative legal studies. But regardless of which term we use, it should be understood as a kind of dynamic process of interaction or interplay, often leading to differences in semantic differences or transformation in the elements or the contents of the doctrine, rather than just a mere transition of law from one jurisdiction to another jurisdiction. And the story of the business judgment rule that I've explained will probably substantiate this observation. So everybody knows or familiar with the business judgment rule under US law, but one scholar said that business judgment rule has a number of different and sometimes conflicting possible meanings. So it is quite challenging to define the business judgment rule. But there are many key aspects commonly mentioned by courts and scholars, like the presumption of no liability, focus on the informed decision procedure, and minimal review of the substance, and gross negligence required. The American Law Institute Principles of Corporate Governance nicely summarizes the business judgment rule like this. So we can formulate or summarize like this, acknowledging there might be quite different understanding of this rule. The requirements, first, the business judgment is made by the directors in good faith, and there should not be a conflict of interest in the subject matter by the directors. And the decision must be informed decision based on adequate review of the relevant information. Probably this one is the most distinct and important part of the business judgment rule. And there must be a rational business purpose. This is kind of the minimal relevance to the substance of the decision. And if these requirements are met, the business judgment rule is successfully invoked. Once BJR is invoked, the court accord deference to the decision, and the directors are rarely held liable. The Van Gorkom, where the directors were held liable even under the BJR, is quite controversial and exceptional case. If there is conflict of interest, then BJR is not applied, but the entire fairness rule is applied. So the defendant have the burden of proving the fairness of the transaction. And once the entire fairness rule is applied, then directors are highly likely to be held liable. That's the cursory summary of the BJR under US law. And what is the BJR under Korean law? The Korean Commercial Code, which is the source of the Korean corporate law, provide the fiduciary duty in two ways. The directors has a duty of care as a faithful manager, and the directors has a duty of loyalty. Both duties are owed to the company. And also there are two bases of the director's liability. First one is the director's liability to the company. It requires the breach of duty or violation of the law or articles of incorporation and loss to the company. And there must be intent and negligence of the defendant and causation between this act and the loss. And this liability to the company, the director's liability to the company, may be pursued either directly by the company or derivatively by shareholders. And also there's another provision that is a basis for the director's liability to a third party, but in this case also it requires the breach of duty of the directors or violation of law. The first time the business judgment rule was mentioned by Korean Supreme Court was a case involving a small community credit cooperative in 2002. It involved that cooperative's non-recovered loan, and the director's liability was at issue. The court said that the relevant portion of the ruling is like this. If the defendant conducted a loan evaluation in accordance with appropriate procedures based on adequate information and in good faith for the company's best interest, then his business judgment would fall within a permissible range of discretion, and he would have fulfilled the duty of care or duty of loyalty toward the cooperative. So it looks quite similar to what is described in United States, or for example, the ALI principles. But under this standard, defendants were held liable because he had a personal interest with the borrower. Actually, he had a previous loan to the borrower. So the court said that the procedure for the loan evaluation was suspicious. There was another interesting case in 2005, the Samsung Electronics case. The directors of Samsung Electronics this was a shareholder derivative suit against the directors of the Samsung Electronics. There were major three claims. The first claim was bribery. The plaintiff argued that the directors caused the loss to the company by using the corporate fund as a bribery to the former president. And the defendant argued that it was necessary and even beneficial to the company, but the court said that BJL does not apply to the act violating law or regulation. Categorically said that you cannot justify your illegal act, the bribery, under the name of BJL. And the second claim and third claim was basically failed investment and underpriced sales of these shares. But in these claims, the court said that if the directors had diligently collected the necessary information and thoroughly reviewed it to make a reasoned business judgment, ensuring it was in the best interest to the company, then they would have fulfilled their duty of care as prudent managers. Under this standard, the directors were not held liable in claim 2, the second claim, for failed investment in another company. But regarding the third claim, the directors were held liable for an underpriced sale of the shares of the affiliate company to another affiliate company. Here, the target was affiliate company, and the buyer was the affiliate company. And the court said that the pricing of the shares was not based on the appropriate procedure or appropriate information. If you have interest more, then you can see the detailed the rulings of the court in my full paper. And there was another case which was most detailed, which provide the most detailed version of the Korean Supreme Court's BJL. And also, BJL is often mentioned in criminal context as well. I will skip this portion. Then probably we can compare the two versions of BJL on the US law and on the Korean law. Basically, their purposes look similar. It aims to encourage the forward-looking and risk-taking approach, granting discretion in the business decisions. And they commonly exclude the illegal act from the scope of protection. The BJL does not shield the illegal acts of fraud. And the requirements look similar. For example, this wording, the rational belief that the judgment is in the best interest of the corporation, that wording is exactly appears in the ACLF principle and Korean Supreme Court, almost verbatim. So this table shows the similarities, of course, a bit of differences between the requirements for invoking the business judgment rule. The Delaware case law says good faith and informed decision, rational business purpose, and absence of illegality, and no conflict of interest. And ALI principles, good faith and informed decision, rational belief, the judgment is in the best interest of the company, and no personal interest, and so on. The Korean court cases enumerates similar ones, like business decision in good faith, and review of necessary information, and rational belief that the judgment is in the best interest of the company, and absence of illegality. But the slight difference is that the Korean court also mentioned that substance of the judgment should not be egregiously irrational. So in terms of the substantive review, Korea is more aggressive. So here are the differences. Gross negligence versus ordinary negligence. Under the US version, the US BJR requires gross negligence to recognize a breach of duty of care, while the Korean law considers mere ordinary negligence is sufficient. And the Korean version of the BJR requires that the substance of judgment should not be egregiously unreasonable, but US version of BJR focuses more on the procedural aspect and refrain from evaluating the substance of the business decisions. the most striking difference is how to deal with the conflict of interest. The US version requires no conflict of interest. If there exists any conflict of interest, then an enhanced standard of review, the entire fairness rule, is applied. But the Korean version of BJR does not explicitly mandate no conflict of interest as a prerequisite for invoking the BJR. Of course, the elements such as a rational belief in the company's best interest or good faith may imply the absence of the conflict of interest, but they are not expressly required. And more importantly, there's no clear legal doctrine akin to the entire fairness rule. And the burden of proof still rests on the plaintiff. It does not shift. So another cursory comparison. So the first line, the US version requires the gross negligence, while the Korean version does not. So in this respect, it seems like the Korea favors plaintiff because ordinary negligence is suffice. The second point is that substantive review. The US BJR under the US version, the courts refrain from substantive review, but on the Korean version, the court reviewed the substance to see whether the business decision is egregiously unreasonable. So in this respect, Korea favors plaintiff. But in case of the conflict of interest, in US version, the BJR stops to be applied, and the entire fairness rule is applied as an enhanced review of a standard, and the burden of proof shift to the defendant. But on the Korean version, there's no concept of enhanced standard of review, and burden of proof still rests on plaintiff. So in this respect, the US favors the plaintiff. Then what is the overall impact of these differences? The overall outcome in United States, so long as the BJR is applied, directives are almost safe, right? Almost safe. And Vam-Gorkom is a rare and controversial exception. So in litigation, the crucial issue is which standard of review will be applied. In Korea, there's no diverging standard of review. But even under the BJR or under the rhetoric of BJR, directors are held liable quite often. Quite often. How often? How often? In Korea, out of 32 Supreme Court cases, civil cases only, that mention the BJR as the applicable standard, I found that at least in 23 cases, the defendant were held liable. Even under the rhetoric or statement of the BJR, the directors are quite often held liable. That's, I think, the real difference between the two versions. And review of these cases shows that directors were held liable in cases of the violation of law and defendant conflict of interest and transactions with affiliated companies. The Korean Supreme Court ruling does not treat the facts of the case in detail, so it is not easy to exactly know what happens in terms of the conflict of interest. But there are many cases about the transaction with the affiliated companies, which may implicate conflict of interest. And in these cases, the directors were often held liable. So under US law, if there's a conflict of interest, then the stricter standard of review is applied, and the burden of proof shifts onto the defendant, and directors are likely to be held liable. But under Korean law, even if there is a conflict of interest, there's no separate stricter standard of review, and no shift of burden of proof. But as I said, the Korean court has more flexibility in reviewing the substance, and the hurdle for the establishing the breach of the duty of care is lower because only ordinary negligence is sufficient. So overall, the courts often recognize the defendant breach of duty and liability, especially in cases of the conflict of interest. So, for example, in cases involving conflict of interest, such as providing questionable loans to a company in which the current director has a stake, a significant shares, the courts recognize the procedural negligence or even substantive unreasonableness on the part of the implicated directors, and that lead to recognizing their liability. So as a result, as I said, even under the BJR or even under the rhetoric of BJR, the liability was recognized in a substantial portion of the cases that mentioned BJR. So despite the differences between the BJR and two countries, if you observe the overall outcome, it suggests a degree of convergence. So the interplay of certain variances, some variances amplify the director's liability, for example, the ordinary negligence as opposed to gross negligence, and review of substance of the decision. And there are other factors that mitigate it, like the application of BJL, even in the conflict of interest situations. But overall, it yields a comparable conclusion. The directors of Korean companies also face significant exposure to accountability in conflict of interest situations. So hastily concluding that the BJL in Korea and the US are similar based on the rhetoric resemblance would be inaccurate. But equally inaccurate is to assert that the BJL in Korea is entirely different from US counterpart, especially portraying it as highly advantageous to directors. So whether intended or not, the Korean adaptation of the business judgment rule bears subtle modifications from the US, resulting in a largely similar overall outcome. I have 1 minute. So the conclusion is already appeared in the title, the similar rhetoric, but different elements and scope and effect, but the overall converging outcomes. And what is the cause for this observation? I think this difference or similarity stems from these factors. The US corporate law distinguishes the standard of conduct, which is the duty of care, and standard of review. But there's no such a clear concept under Korean law. Only the duty of care is the issue, and court just reviews it. And the US court often resorts to different standards of review. For example, BJR versus inter-fairness rule. Even in constitutional law perspective, there's a strict scrutiny and the rule of reason or intermediate scrutiny. And in the antitrust area, proceed legal, rule of reason, and intermediate review. But generally speaking, the current courts are not familiar with such an approach. Just that there's a substantive the requirements and effects of law, and just court review it. So therefore, even if the US and Korean courts reach same conclusion, intuitively same conclusion, the reasoning structure are different. In US, the crucial issue is whether to apply BJR or inter-fairness rule, but in Korea, just whether to recognize a breach of duty of care. And the Korean version of the business judgment rule provide a list of points or elements that the court should take into consideration in determining whether the directors breached the duty of care, whether they reviewed the information and good faith or something like that. So it may have some implications for a comparative study, but I will stop my presentation here. Thank you.
Thank you very much for a wonderful presentation by Professor Chun. Next is the Professor Matsui from University of Tokyo. She is going to leave the comment on Professor Chun's article.
Thank you. I'm Tomoyo Matsui. I'm very honored to have been given the opportunity to comment on the Professor Chun's informative presentation. So let us begin to finish in 10 minutes. Well, there's pause. Okay. So I just briefly wrap up about the similarity and the differences of the US and Korean business judgment rule. And the similarity is that they both protect managers and directors from personal liability for their business decisions made in good faith and with reasonable care. The feature in common is that they both exclude illegal acts. They both have similar requirements like good faith, informed decision, rational belief, and life, and the like. And on the other hand, the article argues that there are differences in certain points, namely the gross or ordinary negligence standard and the ruling over the conflict of interest situations. And I go to the more details with the cases that Professor Chun has provided us in the article. The first case was the 2002 Supreme Court case on directors' personal lending preceding corporate credit extension. The point here is that it was decided under BJR, but it was rather a conflict of interest case. And there are some points that is not clear from the article. I assume that the director in this case had ex-ante board permission, or at least de facto permission. I have heard that the director is still held liable with simple negligence. Then is there any special rule for directors not liability about the fact that they have get the ex-ante permission? And the second case was Samsung case in 2005. The court said that BJR does not apply to the liability, and it denied liability to the failed acquisition with cursory investigation, and it scrutinized and allowed damages to the failed investment to affiliate company. Now, I understand that the bribery of this case was against specific loan and fell into unlawful transaction category, but I imagine that chances were that some legal but extremely inappropriate transfer of money was rhetorically expressed as unlawful. So in that latter case, this case might be understood as a case where negligence standard was very strictly applied when judging affiliate transaction. And about the investment, the transaction involved some share issuance and reselling at lower price. So this case should be understood as shareholding manipulation, not a mere business investment. This transaction damages not only the corporate asset, but also its control on the affiliate. And minority shareholders lose the opportunity to protect the decision and to prevent the risk that the affiliate corporation's profit disappears from their portfolio. Therefore, it was another occasion that BJR was applied to, not mere business judgment. Thirdly, there was Daewoo case, but there were no details of the case. So I assume that this was a case like ECGI case that I will introduce later. So I just skip and go to the next slide. So my major question is that if there are some other rules that can suppress inappropriate affiliate transactions, BJR would not necessarily be used so frequently. And I think our Korean colleagues previously introduced us in another ECGI forum about the 2011 reform of KCC on conflict of interest ruling. So after the 2011, KCC is now likely to have specific rules on dubious transactions. Then the importance of BJR in this field should be decreased after the reform. And I'm not sure. And if some two-tier transactions that involves reselling of corporate shares at unreasonably cheap price is disguised M&A, I wonder KCC has some rules in that matter too. So I just wanted to know. I just want to know about that. And the second question is that if BJR is utilized in various occasions, it is only natural that courts scrutinize the substance of the transaction and apply modified standard to different category of disputes. That might be a reasonableness standard that basic duty of care rule expects the directors to be, or in other words, negligence standard. If the negligence or reasonableness standard itself varies according to the situation, BJR can be very useful to get a reasonable judgment. The shortcomings may be that there should be first be a general social understanding of how the ordinary man should behave in a specific situation, and this social norm takes some time to form. So, this is a new case law that I introduced. The director in this case gets shares on behalf of the depressed corporation in Segaik shopping mall. And this is like the IO case, but shareholders sued the director, arguing that his behavior was in conflict of interest, not the BJR. And court pointed out that the usurpation of corporate opportunity can be decided at the conflict of interest transaction. And this shows the successive reform attempts that KCC underwent about a decade ago. I cut it short because I'm running out of time, but various transactions are now regulated under specific rules, including usurpation of corporate opportunities. So I wonder that presently there should be fewer cases of conflict of interest transactions under the BJR. So I would like to ask whether this speculation is right. And this is the example of Japanese law and how the director's breach of duty of care decided in conflict of interest situation. And this is Article 356, but major point is the 423. And directors bear the burden of proof to ascertain that their transaction does not constitute their breach of duty. And it is considered that the neutrality of the approving body will play a pivotal role. So in the sentence, it says that those directors are presumed to have neglected their duties, but they perhaps protest that they have got the approval beforehand from the neutral body. Okay. And this is Delaware law, but I'll just skip them. There are some courts said that if a director or an officer has in fact got approval of neutral party committee, then ordinary BJR applies to the situation. Now I just go to the next argument, adjusted standard, this one. Okay. Professor Chun said that BJR is mentioned between academics or in courtrooms relatively recently, but I think there should be some time before that, if not articulated, that BJR has utilized in the cases. And if the BJR rule applied to the charitable-involved cases was categorically stricter, then BJR was a de facto tool to materialize a social norm that the directors should stick to the arm's length transactions. And it can not only be used as a mere substitute of vulnerable conflict of transaction regulations, but as an omnipotent tool that can be used in other situations. I just picked up two examples. For example, directors from banking industry can socially be expected to be more prudent as the industry carries public function. And the second example is that about a new social norm. If some new soft law is introduced and socially accepted, that should be weaved into the court ruling and affect the duty of care standard of directors. In the future, perhaps, the ESG-related soft law introduction might also change the standard of BJR, and this will relate to the climate change topic from yesterday. So this is about what I say on this presentation. Thank you very much.
Okay, thank you very much for your comment, Professor Matsui. And so we are going to have a questions and answers Q&A session. Yeah. Yeah.
Oh, thank you so much. Yeah. First of all, thank you so much for this fantastic presentation and also the comments, also incredibly insightful. So I have a question about the comparisons and whether you have considered the burden of proof under US law and Korean law. Because if I'm not wrong, under US law, under Delaware law in particular, the burden of proof is on the plaintiff, but then under the American Law Institute's principle is on the directors, which is also the German model, if I'm not wrong. So I was wondering if you have considered that a possible comparison for your research, so the burden of proof, and whether it is on the directors or on the plaintiff. And also, I was wondering if, as an additional element of comparison, you have considered the BJR in the context of financially distressed firms or firms even approaching a situation of insolvency, but companies that are not yet subject to a formal bankruptcy proceeding. Because under US law, I mean, the rationale, as you have mentioned, of the BJR is in part to encourage risk-taking. But when a company becomes financially distressed, risk-taking can be a dangerous thing. Under US law, which is an exception internationally, US doesn't impose a specific director's duties in the zone of insolvency to file for bankruptcy or to kind of prevent insolvent trading or something like that. So that's why the directors still owe duties to the corporation and they are protected by the BJR. So I was wondering if Korea has adopted a BJR that is also closer to the US approach in the context of the zone of insolvency. Thank you.
Professor Chun, do you want to have some more questions and answer together or one by one?
I will skip Professor Matsui's question, so
Okay, sure. Yeah. So you want to answer one more? Yeah. Okay.
Thank you very much for the presentation. I think I have two comments, one question. The first comment, I think in terms of the duty of care, and I see it's probably the biggest difference is the lack of the exculpation rule, like the Delaware General Corporate Law 102B7. Because before this rule came into being, Delaware court did do substantive review. And still, even with this rule now, theoretically, there's a chance for the Delaware court to do a substantive review when the claim is not for monetary damages, but for injunctive relief. But of course, in practice, I'm not aware of any case like that. So because Korea, to my understanding, there's no such a exculpation rule, therefore what the court have to do, it seems to me, is very natural. You have to do the substantive review. This is one comment. Second, I think in terms of the burden of proof, already mentioned, I saw you put this as one difference between Korea and US. You see, in Korea, it's a plaintiff who needs to prove, the burden of proof rests on the plaintiff. I saw this on one of your slides. But I think in Delaware, it's pretty much the same thing to start with the plaintiff, because good faith, lack of conflict of interest, all these elements are presumed in Delaware. So it is the plaintiff who needs to prove. So in this regard, I think it's the similarity instead of the difference. But of course, the overall common law procedural rule makes this probably works very differently, because in Delaware, in US, under the common law, procedural rule, you need to, first of all, have a sort of a preliminary proof, right? I'm not sure whether this is something, similar in Korea, because the level, the burden of proof, the extent to which the plaintiff needs to prove certain things will be different under a preliminary sort of, review stage, right? These are my two comments. My question actually, I'm quite curious about a thing actually you didn't mention. That is the third party. I'm not very familiar with the Korean law, but I'm a little bit surprised to see that the directors will own. Do you mean sort of it's the fiduciary duties? Oh, fiduciary duties to third parties. If that's the case, so who are the third parties? So what kind of duties would you like to elaborate a little bit? Thank you.
Thank you. I was very excited to hear your presentation because in Japan we have, I think we have almost similar substances with Korean case law, and we do applicate BJR in almost the same formula with Korea in the case of conflict of interest. But we do have a somewhat different consequences, because I found that Japanese court are more loose, or Korean courts are more strict in applicating BJR to conflict of interest situation. So my question is, how do Korean courts handle that those conflict of interest using BJR, do they explicitly mention the situation of conflict of interest and somehow connects or relates to the factors of BJR, or they simply tighten up the standard of review implicitly when the conflict of interest, when they find conflict of interest?
Yeah, you're going to have a hard time, Kyung-Hoon. Many questions. I'll keep this very quick. I'm just curious about the character of some of these cases. You know, I'm a bit interested that actually a lot of directors are being found liable despite the BJR, right? You know, going back to the old research from sort of Cheffins and Black saying that directors never pay out of their own pocket. Are these listed companies? Are these cases being brought by derivative actions? You know, or are these different cases than that? Because I think it's quite fascinating. If some of them are listed and they're being found liable, I think that's quite an interesting finding. If they're not listed, then I don't think that's extraordinary, right? Cheffins and Black didn't look at that, and I think everywhere around the world, you actually find that going on. Yeah.
Thank you for all the very helpful comments and questions. I think the chair is too high for me. Oops.
Me too.
Probably this is designed for Dan, you. So Professor Matsui's comment. You mentioned about the ex-ante permission by the board of directors, and also you mentioned the recent amendment to KCC about the various rules about conflict of interest. It is true that recently Korean law was amended, and now we have many special rules dealing with the conflict of interest situations. For example, we have a special rule for corporate opportunity usurpation, and also have expanded provision on the self-dealing. But all of these, the bottom line of these new rules is that in that cases, you must obtain the permission of the board of directors, period. The basis of the liability remains the same, the provision 399. So these new rules only require to undergo the board approval. They only require the board approval. But even if the board approval is, even they got the permission by the board, it does not exempt their liability. Of course, it may be helpful to avoid the liability, but the fact that the transaction was approved by the board of directors does not entirely exclude the possibility of the liability. So it's a separate issue. So even after we adopted the new rules about the conflict of interest, still we have many cases where the director's liability is at issue. And in that case, probably the similar the elements will be reviewed by the Korean court. And about the burden of proof, yes, it is true that even the Delaware law, basically the principle is that the burden of proof lies on the plaintiff. The plaintiff need to prove the elements for the director's liability. But once the inter-fairness rule is invoked because of the conflict of interest, then the burden of proof shifts. But in Korea, we do not have that kind of clear mechanism for shifting the burden of proof. And as Professor Zhang Wei indicated, in Delaware, the Delaware has a special rule for you said the kind of excluding the liability. And I mentioned that rule in my full paper, but I didn't mention it during my presentation. Yes, that is very important factor in dealing with this issue. But even in states other than Delaware, where without that kind of a special rule, still under the business judgment rule, the court generally hesitate or avoid the substantive review and more focused on the procedural aspects. So, so as I said, this is just a cursory review, but I will refine my full paper in that regard. And then you also said that there's a the third party issue. The Korean law does not say that the directors owe any fiduciary duty toward the third party. The fiduciary duty is owed to the company. But the point of that provision is that if, as a result of the breach of fiduciary duty to the company, if the third party, the breach of the fiduciary duty to the company caused the loss to a third party, and then there is a causation, then that third party has a direct claim against the director. The frequent the example is that when there is a kind of accounting fraud or the window dressing, that means that the directors, the relevant director, breached their duty as a director to prepare the correct financial statement, but they breached the duty, and if some creditors kind of relied on the false financial statement and provided a loan, which turned out to be not recoverable, then in the case, that creditor may have claim against the director. So in any event, that does not mean that the directors have owe any fiduciary duty directly to the third party. I think I probably did my.
Okay, yeah. Thank you very much. Any other questions? If not, yeah, we finished the first session of the today. Thank you very much.